Okay, first one up then is Arya Zishki. So let me see who else is in the waiting room on this one.
Your Honor, Selena Radiola had called in. She's on this case.
Okay, we'll get her in. And let's see, our worker is Ms. Plum. I see her. And let's see, I've got a Brandon Zishki, but I do not see him in the waiting room. So it looks like we've got everybody present on this file.
Is Mr. Weed in the waiting room?
He is.
I just got an appointment or an appearance from him yesterday.
Oh, okay, let me get him in. As soon as we have an audio connection, and we do with Mr. Weed, let's go ahead. Let's see. We've got Mr. Way on behalf of the petitioner. Ms. McCluskey is LGAL. And it looks like each parent has retained an attorney. Is that correct?
That's correct, Your Honor. Ken Hotchkiss appearing on behalf of the mother, Selena Radiola.
And the record should reflect that she is also present. And Mr. Weed?
Attorney Mike Weed here on behalf of the father. I have him, he's in my waiting room. Do you want him here?
You can bring him in. We're doing this on the record.
Okay.
Okay, so we've got a petition here for in-home jurisdiction areas with the mother. Because this petition does not request removal, I can authorize the petition based upon anything that I deem sufficient, and I deem the verified petition to be sufficient. But if either attorney has an argument for why I shouldn't authorize the petition, I'll entertain that now. Let's start with you, Mr. Hotchkiss.
Your Honor, I think the court should authorize the petition, and I think you have the authority to do so. Thank you.
Mr. Weed?
I would ask that I would motion at this time to dismiss the petition. My client wasn't given any notice, and it's a violation of due process. On the front of the probable cause hearing, I understand that the child wasn't removed from his house, but he should have had the right to counsel be present. He was given no notice at all. He also had the right to have the petition read on the record. I don't know if that happened. I don't know if the court went into even an inquiry about the child's membership or eligibility for membership in an Indian tribe per ICWA. But my client, the first notice he ever had of a hearing was the one today.
I appreciate your comments, Mr. Weed, but because when the petition requests in-home jurisdiction, according to the court rule, which I'll recite for you, as soon as I can find it. I will certainly make inquiry regarding Native American ancestry today, but when a petition does not request removal of the child, the court is allowed to proceed by virtue of a preliminary inquiry, which need not be on the record.
Your Honor, I think it's MCR 3.965C.
No, I think it's MCR 3.962.
962? Okay.
You might want to turn there, which I'm doing right now. When a petition is not accompanied by a request for placement of the child and the child is not in temporary custody, the court may conduct a preliminary inquiry to determine the appropriate action to be taken on a petition. A preliminary inquiry need not be conducted on the record or in the presence of the parties. At the preliminary inquiry, the court may deny authorization of the petition, refer the matter to alternative services, or authorize the filing of the petition if it contains the information required by MCR 3.961B, and there is probable cause to believe that one or more of the allegations is true. For purpose of this subrule, probable cause may be established with such information and in such a manner as the court deems sufficient. So we don't hold preliminary hearings on a petition that does not request removal of a child. So what I typically do, I review the petition. If I believe there's sufficient information to justify the filing of the petition, I authorize it. And then the first hearing that is held is the hearing that we in fact are holding today, which is a pretrial. Certainly, Mr. Weed, I am willing to entertain any argument other than the one that you just made about lack of due process to dismiss the petition, but you're going to have to argue a different basis because the one you argued doesn't apply in this situation.
Well, there's also lack of any evidence as to any testimony from the child that this actually happened. It's very thin, and it's based off hearsay testimony mostly as to what the mother has summarized that has happened, because the children's trauma assessment report and any interview that has been conducted by the police didn't really produce any evidence of anything wrongdoing of my client. I don't know. They say it's anxiety and post-traumatic flooding, but I think that even those that interviewed her, the child possibly did not believe her because the assessment did not take place.
All right. Well, Mr. Weed, that's why we hold trials. So based on what you've placed on the record now and previously, I'm going to deny your motion to dismiss the petition. I will ask, does this child have any Native American ancestry?
No, Your Honor.
Oh, Your Honor.
All right. Next step in the process then will be to schedule the matter for trial. I will do that on February 9th at 1 p.m.
Is that a jury trial?
And if somebody demands a jury trial,
I filed a demand for jury trial, Your Honor.
I'm sorry, Mr. Weed, I don't have any of your filings in the file yet.
Okay.
But if your client wants a jury trial, he's certainly entitled to one. What I will do, rather than schedule a trial then on the date that I indicated, I will schedule a pretrial sometime in April, at which time we'll try to figure out when I can actually hold a jury trial. I don't anticipate having any idea sooner than April as to when I will be able to start scheduling jury trials. So I will certainly, let's set a pretrial for April April 20th at 8:30. I won't set up a trial date until then. I think it's kind of pointless to be setting a trial date only to have to move it multiple times, waiting for when I get the go-ahead from the Supreme Court to allow resumption of jury trials.
And that was at 8:30, Your Honor?
8:30.
Okay, that, I got that. Thank you.
Is there anything else the court needs to address today?
Yes, Your Honor. Parenting time. My client hasn't been able to see his child since March. If that requires, whatever, for supervised parenting time, so be it. But I would ask that if he's to participate in services of that sort, that the court would grant a protective order to prevent the petitioner from calling the service providers as witnesses at the jurisdiction trial. So that's kind of a
Give me a moment.
thing.
Yeah, I'm sorry. Give me a moment to review the petition. Mr. Wade, what is the agency's position on parenting time with ARIA?
Your Honor, I would request continued suspension of parenting time, not just because of the allegations, but in addition, there's been an ongoing custody case where I believe Judge Jordan, in front of Judge Jordan has been, I believe, made aware of the circumstances behind this case through the custody case and has found it appropriate to enter a temporary order suspending the father's parenting time through that. I see no reason to change that at this point. As for the request from Mr. Weed regarding service providers, I would just ask that any motion be in writing and a motion in limine. We can certainly discuss that at the pretrial too. Thank you.
There's been no disclosure by ARIA. There's been no allegation of inappropriate behavior towards ARIA. I understand that in a custody case, a different determination might have been made, but I think I still independently have to assess whether or not the parenting time would be harmful. Although when there's a request for permanent jurisdiction, I'd certainly have the ability to deny parenting time, and I get that. But what's the harm to this child of having supervised parenting time with the father?
Well, Your Honor, as Mr. Weed said, the child hasn't seen the father in 9 or more months, I believe.
I
understand that ARIA has not disclosed, but that doesn't mean she hasn't been abused. And I understand the court has to make that distinction to some degree. But we see the trauma that children go through when they're abused and that they disclose at a different rate. I think this case is a very good reminder of that. So that's my position, and I believe Mr. Hotchkiss supports that as well. I don't know what the guardian ad litem believes, though.
Your Honor, if I may interject as well, it was May, end of May. My client corrected me that he's a child, but there's also it's a destructive force to the familial bonds to alienate the affections of a child from their father as well. That also needs to be considered, is the parental bonding, the necessity of that, because there is always the possibility that this case doesn't go long term, and the damage could be irreversible, Your Honor.
The coming national ATM is right across the street.
And I'm sorry, who's LGAL on this file? Ms. McCluskey?
Yes,
What's your
yeah.
position on whether or not the father should be allowed supervised parenting time with Aria?
I know that there's an allegation that pertains to Aria from a disclosure, but I think I agree with the court's statement that the appropriate safeguards could be put into place. It looks like these disclosures from the half sibling were not made spontaneously to begin with. And because the abuse allegations do not pertain specifically to Aria, I think supervised visits would be appropriate, especially considering the respondent's right to a jury trial and his request for a jury trial, which is obviously going to, this case is going to take a bit longer for that reason. So I would support supervised visits. Thank you.
All right, I'm going to take that request under advisement. In the meantime, I'm going to continue suspended parenting time. I want to investigate the custody file further. If I have reason to change my mind on this, I will notify everyone and schedule a special hearing for the sole purpose of considering whether or not I should consider granting supervised parenting time. In the meantime, it will be unsupervised. And unless I schedule another hearing before then, the next hearing will be the pretrial that I've already informed you of. Anything else the court needs to address today?
The court just said unsupervised.
I think you misspoke. I think you misspoke.
You did. That's what I was going to
Whether he should be granted supervised parenting time. I'm not allowing any parenting time in the meantime.
Okay. Just wanted to clarify.
Right.
Thank you.
All right. Well, my order would have been clear. Sorry, I misspoke. Okay. Thank you.
Thank you, Your Honor.
Lady, you can hang up.
Okay, let's see. Next up. Is the Ball Miners. And let's see, we've got Mr. Ball present. Let me get him in the room. And Ms. Parks for the agency, and I've got a Courtney. What's the mother's name?
Courtney,
okay?
Your Honor.
All right, then that must be the mother.
Yes.
Okay, so this is the matter of Reagan, Cash, Gia, and Madden Ball. We have Mr. Way for the petitioner. And let's see, Mr. Brown is LGAL. Is Mr. Ball the only respondent named in the petition?
No, Your Honor. There was an amended petition filed yesterday. I'm not sure if the court is in receipt of that. I did send it to Ms. Carroll, who I don't think is working, but I sent it to all the attorneys as well in anticipation of them being appointed. And Ms. Ball is a respondent on the new petition.
Okay, and I've got a note on here. So let me address, well, wait a minute. We don't have mom's audio connection yet. I just noticed. Okay, Ms. Ball, can you hear me? Courtney Ball? Ma'am, if you're speaking, I can't hear you. Check your settings. Ms. Ball, can you hear me? It looks like we don't have a good connection with her. Let me check. As far as we know, the phone number that's listed on a petition is accurate.
Yes, Your Honor, I can give her a call. She did just send me a text message.
And she's trying to get in. I see that, but we don't have a connection. I'm going to call her on the phone. So you could send her a text letting her know that she should answer the phone if you would, please.
Your call has been forwarded to an automatic voice message.
Ms. Ball, can you hear me? Okay, here we go. Are you Courtney Ball? Yeah, we just lost her. Okay, we'll try again. I'm going to try that phone number again.
Hello?
Good morning. Is this Courtney Ball?
Yes, this is her.
All right, this is Judge LaFlamme. We were having trouble getting you in through the Zoom meeting, but if you're okay with it, you can participate by telephone. Is that all right with you?
Yes, that's fine.
Okay, Mr. Ball is also present. You've both been named as respondents in a child neglect petition. You are both entitled to be represented by attorneys, either one of your choosing or one appointed for you by the court. Do you wish to have the court appoint an attorney to represent you, Mr. Ball?
Does that require for us to adjourn today?
No. That will allow us to continue today.
Yes, and I would definitely like an attorney.
All right. I've got a note from Shannon. The next up for Dad would be Mr. Hotchkiss. And Ms. Ball, do you wish to have an attorney appointed to represent you?
Yes, I do.
All right. Ms. Rebecca McCluskey will be representing you. Counsel, would you each like an opportunity to visit privately with your clients
I would
I
appreciate
would, Your
that.
Honor.
Thank you.
All right, Ms. McCluskey, I'm going to hang up the phone with Ms. Ball so you can call her. We can just keep you muted. I'm going to open a private meeting room for Mr. Hotchkiss to consult with Mr. Ball, and then we'll.
And Your Honor, did the court just call Ms. Ball on the number listed on the petition?
Yes.
Okay, thank you.
All right, so Ms. Ball, you're going to get a phone call from your attorney. I'm going to hang up this call, and then when it's time to resume our hearing, we'll get you back on, okay?
Okay, thank you.
You're welcome. So you should each get instructions on your screen. I'm going to open that private meeting room now. Just come back in when you're through talking.
Mr. Wade? Are they in their meeting room, Judge?
They are.
Mr. Wade?
Yes.
I read the report, the new one you sent me, and I couldn't discern anything different from the first one. Is there anything different?
The petition, you mean?
Yeah, to make Mama responded. I'm wondering what.
Yeah,
What's
I think there's a couple allegations at the end. Let me pull it up.
It would be 7Q and 7R.
Okay, I wasn't able to print it because I got it late last night, but. Can you tell me what Q and R, you don't have to read them to me, just basically what they are. If I shut this.
Yeah, it's just some general non-cooperation with, and I guess some denial about the issues that are occurring in the home.
Okay.
More of the same, just continued. So the kids are still in home.
Okay.
Your Honor, this is Rebecca. We're prepared to proceed. Thank you.
All right, let me get back. Like Mr. Hotchkiss still talking to his client, but I'll at least get your client back in. Does Judge Rapley ever have that problem with her conference phone that sometimes the call doesn't go through?
All the time. We just had the problem yesterday.
Yeah. They came here and made it better by something they did. Because for a long time, it would never go through on the first try, but it would go through on the second try.
Ours wouldn't go through at all yesterday. I had to use my phone.
Hello.
Ms. Ball?
Yes.
This is Judge LaFlamme. We haven't restarted our hearing yet because we're waiting for Mr. Ball to conclude his private meeting with his attorney. As soon as they come back, we'll continue our hearing.
Okay.
Okay, I see Mr. Ball and Mr. Hotchkiss are back. Okay, so this is a petition for which the court is not required to conduct a preliminary exam. Any argument from either counsel as to why I should not at least authorize the filing of this petition?
No, Your Honor.
Well, Your Honor, I believe the court is within its rights to authorize a petition.
All right, and I understand that Mr. Ball has been ordered out of the home.
I don't want to authorize the petition. I don't know what that means.
Well, there's some. Mr.
Because that's the point, is if this petition doesn't have to go any further. So if it doesn't have to go any further, we need to see some facts. We need everything in this petition is contorted. Their lives. We're not going to say facts, but these are my kids. If we don't have to go any further, then that's fine.
Mr. Ball?
Yes.
Mr. Ball?
Yes, sir.
I answer those kind of, I hear testimony and make decisions about whether a petition is factually accurate or not at a trial. I don't do that at this stage.
Right, I understand.
So what I will do is schedule the matter for a trial so that you will have the opportunity to be heard and present your evidence and convince me that I shouldn't take jurisdiction of your children. But in terms of authorizing the petition, I don't take testimony on that issue. I make my decision on whether or not a petition should be authorized based on my assumption that the information in the petition is true. I realize you don't believe it's true, but you will get a chance to contest it at a trial. We just don't do that today. We have to schedule the matter for a trial.
I understand much better now, but I am acting in duress. That's why I'm in this meeting right now, and I don't give anyone permission for jurisdiction over my children. And now that I understand that I get to contest jurisdiction, then thank you, sir, because I didn't understand. I was confused. So now I do. Thank you very much. Trial it is.
You're welcome, sir. What's the agency's recommendation concerning parenting time with Mr. Ball?
Your Honor, at this time, we would recommend supervised by DHS or its designee.
Mr. Hotchkiss, do you wish to be heard on this issue?
I do, Your Honor. I discussed this with Mr. Ball. He's indicated up until even yesterday, he's had unsupervised visits with his children. There's no reason that can't continue. He's not a risk to his children and doesn't believe that it's necessary to have these visits supervised. He's closely bonded with them and would like the court to order unsupervised visits. Thank you.
Mr. Way?
Your Honor, the allegations in the petition are significant. There are significant concerns about Mr. Ball and his, I guess, anger that I think would greatly impact the children if they're potentially left unsupervised. So I believe at this stage, supervised parenting time for Mr. Ball is appropriate. Thank you.
And let's see, I lost track of who's LGAL. Mr. Brown.
I don't even know.
You're muted, Mr. Brown.
What are the allegations? I don't get it. What allegations? You guys are talking about 2000.
I agree with the agency. Thank you.
All right. Based on the seriousness of the allegations, I have concerns if true that Mr. Ball does indeed have difficulty controlling his anger. And I have trouble believing that that's only directed at his wife and not his children. So I am going to order supervised visits. And let's see, let's get this matter scheduled for a trial. No reason we shouldn't move forward with this.
If you could not on February 9th or February 16th, I would appreciate it.
You said not on the 9th?
or the 16th.
Okay. I'm actually going to look to see if I can do it a little bit earlier. Shannon had picked the 9th, but since Mr. Ball wants a chance to be heard, if I can squeeze him in sooner, I will. Let me take a quick peek at my calendar.
Oh, Mr. Hotchkiss.
Right now, I don't have any trials scheduled for the 12th. Any reason you couldn't be prepared to move forward on that day, Council? Realize it's only a couple weeks away.
Yeah, I can be ready.
I can as well, thank you.
I
Mr.
can be
Wade?
ready, Your Honor.
All right, let's, for now, I'm going to set it at 1 o'clock. Council, can you each acknowledge service of the summons on behalf of your clients?
I can do so on behalf of Mrs. Ball, Your Honor, thank you.
Your Honor, if I'd be happy to acknowledge the service of summons if Mr. Ball could confirm that as well while we have him today.
All right, hold on, let me
I think he's
unmute
muted.
him. Yeah, for good reason.
I
So,
believe I'm on.
Mr. Ball, your attorney wants to know if he has your permission to accept service of the summons on your behalf.
Sure. I guess.
All right. We'll make sure that gets done. Otherwise,
I got you.
No, sir, what I'm telling you is,
No, you guys
in order
are
for me to get, Mr. Ball, listen to me, okay?
This is ridiculous.
Listen to me. I'm trying to get you a trial as soon as possible.
I thank you very
One
much,
of the-
sir. My kids are the ones that are really suffering.
I understand that, sir. But in order for me to get this scheduled for trial that quickly, I need to make sure that I've got a summons that's properly served ahead of time.
Okay. Yes, sir.
All right.
Do that. You do that.
All right. And we'll do a pretrial the week before. That will be January 5th at 8:30.
Thank you, Your Honor.
Anything else the court needs to address today?
Oh, Your Honor,
No, thank you, Your Honor.
All right, you're welcome. Thank you. All right, we're going to go back to the trial. Okay, ma'am, that concludes our hearing. Have a good day.
Thank you.
All right, give me just a moment to write a note to myself. Okay. Let's see. I think we are ready to hear from your client, Ms. McCluskey.
Yes, Your Honor. Thank you.
Okay, let me get him unmuted. Mr. Johnson, would you raise your right hand, please? You do swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
You can put your hand down now. Please state your full name for the record.
Ronnie Lee Johnson, Jr.
Go ahead, Ms. McCluskey.
Your Honor. Mr. Johnson, obviously we heard some testimony on the drug screens that you missed and the one you refused. Can you explain to the court the reason why you missed so many of the drug screens that were asked of you?
The reason I missed so many of the drug screens is because Miss Jennings knew that with me living in the country in Albion, that I did not have reliable transportation to Jackson or to the bus line to get a ride to Jackson to do my random drug screen. She's been told many times over and over that I was living over 40 miles from Jackson, and I had no transportation. My parents wouldn't help me out. I had no support, so therefore I couldn't make it to Jackson to do my random drug screens when she told me. But every day for EverHealth, I called in every drug screen every day and reported to her and let her know that I did do it. But the only reason I couldn't make it to Jackson is because I didn't have transportation at the time because I don't have a license.
Okay. And where is the closest bus stop, if you know, to where you were?
The closest bus stop at the time that I was maybe about 30 miles away from me.
Okay. And you said you did call in as required?
Every day. Yes,
Okay.
ma'am. There's a couple times I missed calling in, but I'd also let Joy know right when I missed it that I did let her know I missed it, and she did put it down. But I did call every day when I was supposed to.
Okay. When did you first report to Miss Jennings that you were having transportation issues, if you
I
remember?
reported to Miss Jennings right around when we first started the reunification goal. I reported to her that I didn't have transportation to get in and out of town, and yeah, she's been on this since this is all started. I didn't have a license.
Ms. Jennings referenced some sort of transportation service that they offered. Were you able to ever utilize that transportation service?
No, ma'am. She told me that they had like a dial-a-ride or a dial-a-service or something like that.
Okay.
And I didn't have Medicaid or insurance or anything to cover it at that time, so I couldn't use them services provided to me to use that bus line.
So the services that Ms. Jennings referenced were to be at your cost?
Right. I had to find my own way. Yeah, I had to find my own way. Yeah.
Okay. Employment, the petition references that you had at least 3 employers, and I want to go through each one. It sounds like McDonald's was the first employer you were employed with. Why did you leave that employment?
Well, my first employment that I had when I was back in Jackson, I was working at Menards. I was working at the Menards, and the reason that happened was because I was there for a couple of months. I would do the outside yard lumber receiving shipping, and I didn't know about their point system, and they had me on a point system because I was given a paper by Miss Jennings herself stating that I needed to give it to my employer, showing that my son was a temporary ward of the state and that I was mandatory for all my appointments and everything else I was told to go to him. So with me having to go to every mandatory appointment and observation and everything else caused me to be put on the point system to where I lost my job.
Okay. And what's the point system? Is that some sort of penalty for missing work?
Right. Yeah. Every time that I would have to miss to go see Dakota or go to an appointment or Lifeways or whatever, I would get 2 points put on me every time. And you can only go to 10 points before they fired you. And I got to 9.5 and they dismissed me because of everything I had going on for Dakota. I couldn't concentrate at work. I was constantly on the run doing appointments, and that messed up my employment.
And then let's move on to McDonald's. Why did you leave that employment?
The reason I left McDonald's for is because they were shorting down in hours. They didn't have enough hours, and they had too many people, so they were letting people go. So I left there and I went to Myers over on East Michigan Ave.
Okay. So you left McDonald's because they let you go because they
Right,
didn't?
I was down to 6 hours every 2 weeks working at McDonald's.
And then you went to Meyer, and why, how long were you employed with Meyer?
I was employed with Myers for a little over almost 2 months.
Okay, and why did you leave that employment?
Because Miss Clemens's cousin, Daniel McMurtry, she would have him come to my store, bully me. She would have him follow me from my work, stalking me, cussing at me, threatening to beat me up at work, embarrassing me in front of all my friends at work.
Okay.
He would basically bully me, and that caused my job to end.
Okay, and you were let go because of these altercations?
Yes, ma'am.
that
Or I'd have still been working and still been had my job by now.
Okay. Are you currently employed?
I currently am, yes, ma'am.
And where at?
I work at Southern Appliances.
Okay. And when did you secure that employment?
Your Honor, I'm going to object to anyone telling Mr. Johnson how to testify. This is not how this works.
Mr. Johnson, you're on your own. You can't get help from somebody else in the room.
That's fine.
And Mr. Johnson, ideally, you're the only one in the room if that could happen, okay?
Yes, ma'am.
So Southern Appliance, Mr. Johnson?
Yes, ma'am.
And when again did you start working there?
3 months ago.
Okay. And you've been employed consistently there for 3 months?
Yes, ma'am. Every day, 12 hours a day.
Okay.
I work out on the farm, take care of farming animals.
Okay. And about how many hours a week?
I'd say probably about 50, maybe a little over.
And what's your hourly rate?
My hourly rate is at $10 an hour.
Okay. If Dakota were to be placed in your care with that employment, would you be able to financially support him?
Yes, ma'am, I sure would.
Okay.
Would not a problem at all.
Okay. Well, let's move on to housing. Obviously, we've had some housing issues over the course of the case. Can you explain to the court the steps you've taken to secure appropriate housing, Dakota?
The steps I take in securing appropriate housing was when I was back in Michigan, I applied for the Jackson Housing Commission, and I was doing it as reunification and homeless. So with that being said, that bumped me from being number 136 down to number 6. And when I left Michigan, I went down here to Ashburn, where I'm currently at, to the Ashburn Housing Commission, and setting up housing down here to have my case switch from up there to down here.
Okay.
So I can have housing.
So you do currently have housing in Georgia?
Yeah.
Okay.
I do.
In that home, would there be space for Dakota?
Yes, ma'am.
Okay. And how long have you been in that current housing?
A little over 3 months now.
Okay. Is there any reason you would have to leave that housing in the near future?
No, ma'am, not for a second.
Okay.
Everything's paid.
So obviously we heard testimony that you did complete parenting classes shortly after the referral was made. Can you explain to the court how you believe you've benefited from those parenting classes?
I benefited from the parenting class because when this first started, I didn't know how to handle Dakota. And going through the 12 weeks of doing my classes, I learned how to better understand how he's feeling, how to deal with him, what he's going through, how to comfort him, how to take care of him, how to be there for all his needs. Like, I became a lot better parent. Understanding all this, I learned how to support him emotionally, physically.
When you say you learned how to comfort him, for example, can you give an example of what you learned in the parenting classes?
Say like when he's feeling bad and he's screaming his mouth off, and instead of sitting there jumping to conclusions, getting all frustrated and everything, I learned to figure out why he's sitting there feeling bad, what's wrong with him, in a calm, mannered voice, comforting, and try to resolve it from there. Because there's no sense of losing your temper with a toddler, because they can't understand to tell you what's going on with them. So it's better with me doing my class that way. Now I understand how to comfort him in a lot more positive way than it would be just not having classes and freaking out. Like, I learned how to comfort him.
And let's use at least one more example. That you said you learned ways to meet his physical needs. Is that correct?
Yes, ma'am.
And what would be an example of that?
His physical needs is that he likes to be held all the time. And that when he starts crying, I hold him, I rock him back and forth, I feed him, I change him, I love him, I do everything that a father's supposed to do.
Are there any other specific skills you think you learned in the parenting classes that you'd like the court to know about?
I learned how to be a better parent than what I was. I learned that it's not all about me, it's about him and everything about him. That he looks up to me for his protection, his safety, his love, his comfort, and everything. You know, I learned everything doing that with Mr. Duncan for the last 12 weeks of parenting class. Like, I learned just so much.
Okay.
And it helped me be a better parent. And I used them skills on Dakota so many times, and it's worked and it's comforted him. And like me and him's done really well since all this.
And so you believe you were able to use those skills when you were able to do in-person parenting again? Is that correct?
Yes, ma'am.
Can you give the court an example of one of those parenting times that you were able to use something you learned?
I sure can. Okay, I came to visit and he was just starting teething. And he was sitting there and he was screaming, throwing a fit. And I would rack him back and forth and I'd be like, it's okay, you know what? Daddy's here, daddy loves you, you know, it's okay. And I would rub his head and everything. And I would like rub in front of his lips, like his gums. Like I would like try to comfort his gums and everything and give him teething rings. I was just there for him. Like I was there for everything that he was going through. And
any other examples that come to mind of anything you could put into use during parenting time? If not right now, that's okay.
I mean, I read to him. I do everything that a father is supposed to do for their child. I change them, feed them, read to them, make them laugh, make them giggle. You know.
So we'll move on to therapy. Obviously, you've been engaged in therapy with Miss Miller.
Yes.
And there was some testimony that you'd missed a few of the sessions. Can you explain to the court why you missed the sessions with Miss Miller?
The reason I missed the sessions with Miss Miller is because when I was staying in Albion at my parents' house, I didn't have Wi-Fi, so I wouldn't have Wi-Fi to call her because at the time I wasn't working. I was staying in my tent, so I didn't have a way to pay for my phone bill. But I would have to walk across the street, and then as soon as I know I'd missed it, I would call Caitlin right back and I would reschedule something right back with her as soon as I missed it. Like they were never intentional because I do love my therapy, and Caitlin, she's just awesome. You know.
And that's Miss Miller.
Yeah, Miss Miller, yeah.
So we heard some testimony that obviously you benefited from the therapy as well. Why do you state that what did you enjoy most about therapy?
I enjoyed most learning the new coping skills on how to deal with my anxiety, my panic attack disorder, and my frustration and everything else. Like me and Miss Miller, we sat there and she taught me how to, you know, touch my fingers like 1, 2, 3, 4, 5, you know, and just everything. And, you know, just when things are getting so bad, she taught me to think about Dakota. If Dakota was in front of me, would he want to see this and everything? So I act like he's with me at all times. And I sit there and I'm like, okay, I don't want him to see this. He doesn't need to see this. And I mentally use that in my head to calm myself down. And I write in my notepad. I write every day how I'm feeling and what's going on with me. I have journals. I have just everything. I enjoyed my therapy. I didn't even want to stop doing therapy when this was over. Like I still call Caitlin still and still try to talk to her for like 10, 15 minutes. You know, I still talk to her.
So those tools you just referenced, the physical tricks, the thinking of Dakota, the journaling, those all came from your therapy with Miss Miller?
Yes, ma'am.
And you still use those tools today?
Yes, ma'am.
How else do you think you've benefited from Miss Miller's sessions?
I learned how to slow myself down. I learned how to concentrate more. I learned how not to be so impatient. I learned I learned a lot. Like there's so much. It's just since this all started, I was a little out there when all this first started because I really didn't know anything. But for the whole year, like I changed myself. Like I changed myself for the better. Like I learned I don't have panic attacks no more. I don't have freakouts no more. I don't have outbursts no more. I might lose my temper every so often, but who don't? You know, like I'm not the perfect parent. There's no such thing as the perfect parent, but I try as hard as the next dad to take care of his kids and provide for his kids.
Great. And you believe all of those benefits have come directly from your sessions with Ms. Miller?
Yes, ma'am.
And you stated that you would like to continue with therapy, is that correct?
I love therapy. Yes, ma'am.
Okay. And I know there was some testimony about you having not had engaged in Georgia yet. Can you explain why that hasn't happened?
The reason with that is because where the town that I live in, Ashburn, is a little pecan peanut town. It's just a little town. And Tifton is a little ways away, and not having my transportation, I haven't got there to get it started yet. Like I've called and they told me that all I got to do is come down and start my intake, because I did go there before and I thought I did my intake and everything. And when I left, I guess it didn't count. So
Okay.
I have attempted to go there already and do it. It's just, I need to call them, set up an appointment, and go right back and start.
So the service provider that the agency recommended is in Tifton, Georgia?
Yes, ma'am.
And I know you
Legacy,
said that, okay, I'm sorry. Go ahead.
it's Legacy Behavioral Health.
Okay. And I know you said that's a ways away. Do you have an estimate as to how many miles or how long it would take you?
It's like 20 miles. So it'd probably take maybe like 20, 30 minutes.
Okay. But you did visit that location?
Yes, ma'am.
Do
I
you
did.
remember when that was?
That was maybe, let me see. That was just a little over a month ago. That wasn't too long ago. That was just a little over, maybe not even a month yet.
Do you remember if it was November or December?
I want to say it was like early December. I went there.
And
It-
what happened when you were there specifically?
When I went there, I did the intake process and everything, and I was getting ready to see a doctor, and something came up, and I told him I had to go, and then I called back a few days later. She told me that I was waiting to be waiting to be called by my therapist there, and when I went to call back to talk to my therapist, see what was all going on, they said that my intake wasn't even in process, that I had to come back and redo another intake with them.
Okay. Did you leave the intake paperwork incomplete? Is that
No, everything was complete.
okay? Do you remember names of anyone you spoke to or the name of the therapist? Not at this time.
Sure. Oh, I'm sorry.
Nope, no problem. Can you give the court a little more detail as to specifically why you moved to Georgia?
I moved down to Georgia because, I moved down to Georgia because being up in Michigan, my family is addicted to pills and alcohol really bad. I was living in a tent, going nowhere with myself. Basically, not even making no progress at all. I moved down to Georgia because it was better for me. I'm an upstanding citizen now. I can walk with my head up high and my shoulders out. Like, I work full time now. I benefited a lot. It's been a lot more beneficial being down here in Georgia. And the reason I came down here in Georgia is because my friend wanted me to come back home because he was helping me get Dakota home. And he recently passed away 4 days after I got home. So therefore, I moved up here to Ashburn, Georgia, and got on my feet. I got a place, I got a car, I got a job full time.
Okay. So you do have reliable transportation at this point?
Yes, ma'am. I got a 2006 Pontiac G6 four-door sedan.
Very nice. And when did you get that?
Like 3 months ago.
Great. Why specifically do you call this family in Georgia your adopted family?
Because they always open their door to me every time I've been on my own. They've never closed the door on me. They've always fed me. They've always loved me like one of their kids. They've always helped me with whatever I needed. They showed me more family support and love than my own real family up north. My family down here has never turned their back on me for a second. I can go to my family right now and say, hey, I need to use the car, and my family will support me. Like, my family they're there for me emotionally, physically, everything. Like, my family is a really good thing down here.
And how long have you known this family?
I have known my family over 6 years now.
Okay. And how many individuals are we talking about? What kind of support network?
5.
So if the court were to decline the request to terminate your rights and would entertain placing Dakota with you in Georgia, are you willing to continue to engage in services fully?
Yes, ma'am. No problem at all.
And you probably heard Ms. Jennings testify that the agency doesn't have a contract with a service provider that would provide drug screens, so those would be at your cost. Can you do that?
Yeah, I can do that. Legacy Behavioral Health actually does drug screens down there, so I could have that done too, and do a release of information.
So the service provider that the agency referred to you also does do drug screens? Oh, okay, great. If the court were to decline the request to terminate your rights, would you be willing to move back to Michigan if it meant getting Dakota back?
Oh, yes, ma'am.
Okay.
Definitely.
And would you be able to set up a similar support system here in Michigan?
No.
Okay.
Honestly, with me being down here, Dakota would have just a great life. Being up in Michigan, we would just be miserable.
Okay. Well, it sounds like from all of the testimony, transportation was an issue, and it's your testimony that has been resolved. Is that correct?
Yes, ma'am.
Okay. Is there anything else you'd like the court to know when making its decision today?
Yes, ma'am.
And what would you like the court to know?
My name is Ronnie Johnson. I am Dakota Riley's father. I never wanted my son to go through this. My son did not deserve to go through this. I understand I made some poor choices, but I only done nothing but try to better myself and give my son a better future for himself. So I believe I took the right steps in my heart, getting myself stable and secure in a home for Dakota. I don't want to give up my rights to my son. I always wanted to be there. I tried talking to his grandma about staying in his life, about being there with my son. I don't want to lose my son. I'm willing to keep doing everything I have to. He is my world. I am a better man since I've had my son. I've opened my eyes and I've seen things in a whole lot more different ways. Like I put Dakota first through everything. I think about everything with Dakota, how things would affect him if he was around me. And, you know, I bust my butt 7 days a week, 12 to 15 hours a day working. I break myself down and I do it all for my son because I love my son and I want my son with me. He doesn't need to be in placement. He doesn't need to be in a foster care system. He needs to be home with his daddy. His daddy that loves him and will support him.
And one final question. Are there any services that you think would be beneficial to you that have not been offered to you by the agency?
No, ma'am.
Okay. I have no further questions at this time. Thank you. The other attorneys may have questions for you though, Mr. Johnson, okay?
All right, thank you.
Way?
Thank you, Your Honor. Mr. Johnson, you said part of your transportation issues in Michigan were that you didn't have a driver's license, correct?
Yes, sir.
Why didn't you have a driver's license?
The reason I didn't have a driver's license is because when I just turned 18 years of age in Michigan and I went down to Secretary of State to get my license. I had a permit. And my dad had me driving his Dodge Dakota. It was an 04, and it had improper tags and insurance and everything. So Calhoun County winded up putting me in jail for that. And they winded up giving me 35 days in county and then turn around and billed me the rest of it for $384. So I've never had a chance to get a license yet, only a permit.
Okay, so your license in Michigan is suspended, correct?
Yes, sir.
Okay, so how are you driving in Georgia then?
My ex-girlfriend, she lives around here. She takes me everywhere I got to go. She's a valid driver. She's got a valid driver's license and my car is legal, everything.
Okay, so you have a girlfriend in Georgia?
Ex-girlfriend.
Ex-girlfriend, okay. We heard Ms. Jennings talk about using your parent, she said, I believe that you could use your parents' vehicle in Albion. Are you saying that you never told her that?
I've never drove my parents' vehicles ever. I've had my own vehicles back in Michigan.
Okay, but I guess, did you hear Ms. Jennings' testimony about that if she got gas cards and reimbursement, that you would be able to find a way? Did you hear that testimony?
Yes, sir. My father.
Okay, I'm not, I just, it was a yes or no question. Is that true or is that not true?
That's true.
Okay. You worked at Menards. What were you working? Okay, and that's the Menards in Michigan Center, is that correct?
Yes, sir.
And you were living in Albion at the time?
No, sir. I was living right across the road in Michigan Center on Fairfax Avenue.
Okay, so you could walk to Menards?
Oh, yes, sir.
Okay, when you were working at McDonald's, where was the McDonald's at?
Directly right in front of the Menards.
Okay, and were you living over by Menards at that time?
Yeah, still on Fairfax.
Okay, how long did you live at Fairfax?
We lived at Fairfax. I lived at Fairfax for a little, maybe 5 to 6 months around that time.
Okay, when did you move to Albion?
I left Miss Clemens Father's Day of last year.
Okay. So sometime in
Late May.
around Father's
Late
Day.
May.
Okay. So you were living in Jackson for at least for more than half of the time that your case was open and you were in Michigan, right?
Right. I was.
Okay. And so when you worked at Meyer, were you living on Fairfax as well?
Yes, sir.
Did you ever work when you were in Albion?
No, sir. I've applied for work in Albion, but being so far out in the country, I didn't have a way to work.
Okay. When's the last time that you saw Dakota in person?
Last time I seen Dakota Riley in person was I want to say around July, August.
And how many times have you seen Dakota in person, approximately?
I've seen Dakota, or I've seen him. I used to be at every parenting time until COVID-19 started. So from December 9th till time COVID started, and then we took a break and did it over video, and then we picked it up. So I've seen Dakota maybe like 30, 35 times. I used to see Dakota all the time. I never would miss a parenting visit.
I have nothing further, Your Honor.
Thank you.
Questions, Mr. Brown?
No, thank you.
Questions, Mr. Kelly?
No questions, Your Honor.
Any redirect, Ms. McCluskey?
No redirect, Your Honor. Thank you.
Give me just a moment. The court has no questions. Any further presentation, Ms. McCluskey?
No, Your Honor. Thank you.
And does anyone else have a presentation?
No, Your Honor.
No, Your Honor.
Okay, sounds like we're ready for arguments. I'm going to take just a very short break and I'll be right back. Okay, before I hear arguments, Ms. McCluskey, to your knowledge, is Ms. Reyes planning to do a release this afternoon at 1 o'clock?
I have not heard from Ms. Reyes. I sent several emails and called 2 or 3 times, and I have not gotten a response.
So are you prepared this afternoon, Mr. Way, to move forward with termination?
I am, Your Honor.
All right, the reason I asked is I wanted to make sure if she was planning to show up at the courthouse that we let people know downstairs. Given the lack of response, I'll just deal with that at 1 o'clock. Okay, I'm sorry. Mr. Way.
Thank you, Your Honor. I believe Ms. Jennings laid out a pretty thorough description of the case, the efforts that she made. To me, she had a very good grasp of the case. She did a very good job coordinating services to the best of her ability. In terms of the mother, it's clear that she didn't do a whole lot, that there's still significant barriers, so I won't spend any time unless the court has questions regarding the mother. The father's case is certainly closer, but I still think there are several barriers that are concerning to me. That he's relying on the transportation issue to kind of explain everything away, but to me, there's just some inconsistencies in there that don't make a whole lot of sense. He seems to be able to get to everywhere but the things that he needs to do to get to Dakota back. And I think he frankly misrepresented the difficulty he had throughout the case. When we found out later, it was really only 2 or 3 months that there was maybe a transportation issue to get to from Albion to Jackson. The rest of the time he was living in Jackson. He hasn't really seen Dakota in person much at all, despite being offered that, especially recently. So I question the bond. I question whether he may have learned some things on how to deal with an infant or a toddler in parenting class, but using those skills in parenting time while caring for Dakota are 2 completely different things. Likewise, while I acknowledge that he made progress in therapy, there have still been ongoing issues with his outbursts, with workers, with a variety of different people as recently as October 2020, which is after the point that he moved to Georgia to have this great emotional support system. So I don't know that argument holds a whole lot of water to me either. There was a suggestion that he had difficult coordinating appointments. He didn't have, I don't think, as many services as the typical parent has. And he was also given the luxury of a case manager whose job is to help with these things. Ms. Jennings put Mr. Johnson in every position to succeed possible. My final concern really is that he's using Xanax and THC, and I know THC is legal in Michigan, and I acknowledge that, and I don't have a problem with people using THC unless there's some mental health issues, because using unprescribed THC, unprescribed Xanax certainly has the ability to affect the chemicals in your head and prevent medicine from working properly. And I suspect that he's using THC to cope when he should be using other coping mechanisms, including potentially medications. And then the big hang up is he moves to Georgia during all of this. He's told by his therapist, Ms. Jennings, this is going to make things more difficult. And it certainly will. We're certainly not in a position to return to go to home. We would need to at least move to unsupervised parenting time prior to reunification. And I have no idea how we go about doing that when he's living in Georgia. I believe multiple termination bases have been shown as it regards, with respect to both parents, I think it's clearly in Dakota's best interest that the termination take place. Dakota is with his siblings. He's being well taken care of. He just would not have the same stability with either of his parents. There's no real bond because of the lack of progress, the lack of participation in in-person parenting time with either parent. And we just haven't seen the progress in real life. Like, we can make progress in a counseling session over Zoom. We can make progress in a parenting class where you take a test at the end. But until we see it in practice, where you're controlling your emotions and you're actually physically taking care of the child, I don't consider it progress otherwise. So I'm asking that, based on the testimony, the court terminate both parents' parental rights and free up Dakota to be adopted in the same household as his siblings. Thank you.
Your Honor, I object. I do. I object because he's putting me here.
Mr. Johnson, Mr. Way is free to make any reasonable arguments he has from the evidence. Your attorney will have an opportunity to address those things, and I'm going to give her that opportunity now.
Thank you.
Go ahead, Ms. McCluskey.
Thank you, Your Honor. So to frame where we've come to, obviously DISPO happened January 29th of this year for my client. Since that time, he was offered 70 parenting times. He's participated in 65. He completed a psych eval almost immediately, strangely, after DISPO on February 6th, according to the petition. Substance abuse evaluation referred December 2019, and his intake was February of this year. Parenting classes referred, again, December of 2019, and completed that 8-week course in May of this year. Obviously he was ordered to maintain contact with DHHS. He clearly has done so. There was no testimony to refute that. And obviously from the testimony on all of the services and the communication, that was clear from the presentations. Maintain a legal income. Obviously that's one of a little bit of our challenges, but Mr. Johnson's testimony is credible. He testified to the 3 employers he had and the justifiable reasons that he had to leave those employment. And he has had periods of unemployment, but certainly this is not one of those situations that we see regularly where a parent is just unemployed for the pendency of the case, or unemployed more often than employed. And then honestly, leaving one of those employers was directly attributable to all of the services that the agency required. And I will note that the record would reflect, and the court has taken judicial notice of the file, it was per my request on behalf of Mr. Johnson that the court declined to order intensive outpatient services, because we knew from day one that this was a very intensive service plan. And with the transportation issues that we were aware of from day one, that Mr. Johnson would struggle with that. And that's why the court declined to order that service. So the longest stretch of employment, obviously, is the one he's in now, with a support system that he's testified is extensive and certainly helpful. And lastly, drug screens. Obviously, drug screens were an issue, and I had to have this conversation with my client. But again, Mr. Johnson's testimony is credible. The reason he could not get into town to drug screen, and certainly we all know these rural areas like Albion and Parma, it's impossible to get to a bus line. And then upon his testimony, Ms. Jennings failed to mention that the service they referred Mr. Johnson to was one that had to be at his cost. And that just boggles my mind. I was unaware of that. I never would have suspected that the agency couldn't find a way to offer him probably the most important service that he needed to get to service, which would be transportation, to get to his services, to get to parenting time, to maintain employment. And the agency failed him in that respect. So at the end of the day, Mr. Johnson has completed all services. I think This is one of the few cases that I found his testimony, again, compelling on all of the benefits that he outlined that he's gotten from the services, the tools he's learned, the very specific examples he gave as to how he implemented the tools he's learned. And the agency gave no substantive testimony as to a lack of benefit that Mr. Johnson has received from these services, other than the subjective observations of Ms. Jennings, which are directly contradicted by the testimony of Ms. Miller, who testified very compellingly that Mr. Johnson engaged right away and has made a lot of progress, especially recently. I also found Mr. Johnson's testimony regarding his love and engagement in therapy very compelling. As far as mental health, Ms. Miller's testimony was clearly the most credible, and her testimony was very positive to Mr. Johnson. I know I've heard Ms. Jennings testify in this manner in the past. She tends to, quote unquote, diagnose mental health issues with these parents, and she has no authority to do so. It's just he loses his temper with her, which we see all the time, and that to her is some sort of mental health issue. So transportation now resolved, housing and employment now resolved. And finally, I think the quote of the day was more difficult. Everything's more difficult because of this move, yet not impossible. And we do see these interstate moves with parents all the time, and ICPC is clearly not convenient, but it's not impossible. And it's what we owe these parents, and it's what we owe these minor children. So the fact that all of the testimony either proved or certainly didn't disprove the fact that Mr. Johnson moved to Georgia because that bettered his life. At this point, he has the infrastructure that was ordered. He's doing well. He has a support system. So we would be terminating a parent's rights solely based on the inconvenience of an interstate move. At least that's my take on all of the testimony. And finally, Mr. Way mentioned that we can't see the benefits in practice, and my client doesn't have a relationship with Dakota. Well, that's the agency's doing. Those are the circumstances we're in. That's not the fault of Mr. Johnson per the testimony here. Dakota was removed after birth. Then we had COVID. We normally would have had a period of time of all in-person parenting times. And unfortunately, there were some telephone visits, remote visits. And seeing the benefits in practice, again, we can't see those benefits in practice if we're not doing in-person parenting time or the child's not placed with the parent. So it's kind of a catch-22, and I don't think it's fair to use those circumstances against Mr. Johnson. So we would argue vehemently that Mr. Johnson has not only completed all of the services that were required, he has benefited and demonstrated from his testimony the benefit, and that the agency has not met its burden, and we would ask that the court decline the request to terminate Mr. Johnson's rights. Thank you.
Thank you. Any argument, Mr. Kelly?
After discussions with my client, I would leave it in the court's discretion.
Okay, Mr. Brown.
Judge, just briefly, with regard to Ms. Clemens, obviously there's a factual basis. She hasn't done much. And the child is placed with her mother, along with her other children who've either been adopted or placed in guardianship. So I believe with regard to Ms. Clemens, it's in the best interest of Dakota to terminate Ms. Clemens' parental rights. With regard to Mr. Johnson, this seems to be a case of two different Mr. Johnsons. The ones that set forth in the termination petition and the reports and the text messages and the screenshots, and the Mr. Johnson that presents here today. He presented very well. Ms. McCluskey did a very fine job. He seems sincere. He doesn't seem like the same person that's outlined in the petition. Has Mr. Johnson done some good things with his service plan? Yes. And I don't know whether the economic factors and COVID set Mr. Johnson up for failure. He didn't fail. He did some things. I wish, and my only question was of Miss Miller, did she try to talk Mr. Johnson out of moving to Georgia? And she said yes, realizing how difficult it would be to monitor him, to make sure that he is getting the services he needs. I'm not so concerned about the drug testing. He tested positive for THC. That's the least of my worries in this case. The most worries are his stability and mental health. There's no way to monitor them. I think Miss McCluskey did a good job. Mr. Johnson presented himself well here. It's a question of whether those 4 months we were shut down for COVID, whether you're going to give him another 4 months to show that he can do what he's supposed to do. Has there been a statutory basis? Most likely, yes. Is it in the best interest at this time to stay where he is? Yes. The only question is whether because of COVID and his move to Georgia, whether arrangements are going to be made to see if he can continue to make progress. I'm torn. Dakota is well off with his maternal grandfather, mother right now. I know that's not the test, but my position right now is that there is a factual basis or statutory basis, and it's in his best interest. Again, I'm torn. He presented very well here today. I have no doubt that he loves Dakota and wants to do the right thing. But these outbursts that have been reported by Miss Jennings, as much as yesterday, they're a tale of two people, one that testified here today and the one that is portrayed in the reports. So that is my position. It's just a matter whether the court's going to give him more time because of the period from March till July when we were initially shut down, and Mr. Johnson's regretful move to Georgia. He was making progress while, admittedly, by the therapist while here. I think that was an impulsive move on his part. This could have been done later. He should have focused on Dakota and stayed here, but that's not my call. He made his choice. I feel sorry. Thank you.
Thank you, Mr. Brown. Anything further, Mr. Way?
Just briefly, Your Honor, I really take issue with, and this has happened multiple times, the classification that Ms. Jennings is quote unquote diagnosing Mr. Johnson. That's clearly not what's going on. She's reporting legitimate concerns about his mental state that she has observed or has been told, as is her job. And it's so important to report those things, because going to a class, going to counseling is only good as if you implement those things after the fact. You know, you can be charged, or you can be convicted of domestic violence, go to a class and say, okay, well, I'm not going to beat my spouse anymore. But then if you go back, a month later, finish the class and you beat your spouse, you're still a domestic abuser. you have to show these things in practice. And it does, it's not about diagnosing it, but just it's reporting facts that lead us to conclusions on whether this change is actually real. And based on what we've heard, there are still significant issues with Mr. Johnson's mental well-being. Thank you.
Thank you. Thank you, everyone. So I first want to address whether statutory grounds have been met for termination of the mother's parental rights. The bases that have been offered are there's a reasonable likelihood based on her conduct or capacity that the child would be harmed if returned to her care. Secondly, that she was a respondent in a proceeding, that 182 or more days have elapsed since the issuance of an initial dispositional order, and the conditions that led to the adjudication continue to exist, and there's no reasonable likelihood that they will be rectified within a reasonable period of time, considering the child's age. The third basis offered is that there have been, since the dispositional order, other conditions that have been brought to the court's attention. I don't believe that basis applies here. I don't have any significant testimony that anything on the mother's part is new. It's something that arose since the dispositional order. And then finally, parental rights to one or more siblings have been terminated due to serious and chronic neglect or physical abuse. The parent has failed to rectify those conditions that led to the prior termination of parental rights. I believe the first, second, and fourth all would apply to the mother. The testimony established clearly and convincingly that from a prior psychological evaluation given in another case, I believe a Calhoun County case, in which her parental rights ultimately were either adversely terminated or surrendered under threat of termination, that diagnosed her with a number of significant psychological issues, personality disorder, with borderline and antisocial patterns, stimulant use disorder, opioid use disorder, child neglect, child psychological abuse, other specified trauma, stressor-related disorder. That evaluation noted that she's prone to become easily overwhelmed and frustrated, self-preoccupied, and this will occur primarily during times of stress or when there are relationship difficulties. There were also recommendations concerning her substance abuse treatment and emphasis on relapse prevention, the need to learn skills to increase her stress tolerance, capacities to regulate her emotions, therapy focusing upon abuse and neglect, and a DBT program, daily journaling, task list, essentially a long list of psychological issues and a long list of things needed in order to address those conditions. So she was referred to Lifeways for individual therapy and psychotropic medications. She did complete that intake. But in terms of following through on the services that were recommended in that psychological report, she missed or canceled 39% of her therapy appointments with the counselor. According to the counselor's testimony, not only was her attendance inconsistent, she hasn't seen her at all since October. And in the session she did attend, she struggled to engage. She made a small amount of progress, but nothing significant. She still struggles with interpersonal relationships that keep her from functioning independently. Her focus on relationships outweighs her focus on her children, which creates the real problem here as far as their neglect is concerned. She clearly failed to fully engage in the therapy services, and she clearly failed to show benefit from those services. In addition to these services, she was ordered with respect to psychotropic medication and medication reviews. She missed 50% of her appointments with her doctor. 6 appointments were scheduled. She only went to 3 of them. And the testimony established that throughout the duration of the case, she continued to show and display mental health concerns. Admitted herself that she's not mentally stable, disclosed feelings of depression, anxiety, and being overwhelmed, which is absolutely a recipe for disaster when you have children that you are so overwhelmed that you cannot properly attend to their needs. You can't seem to put your children's needs over your own, and that's clearly been demonstrated here. With respect to substance abuse, she did complete an assessment and was ordered to continue her therapy services through her primary therapist. And I just want to make clear my memory of the testimony as to her relapse. I thought I remembered Ms. Miller testifying to an acknowledgement of relapse on her part. But I'm not finding it in my notes. Give me just a moment. In any event, it was clear that she missed most of her scheduled random drug screens, 43 out of 56. Had a positive drug screen for THC, had 2 positive drug screens for amphetamines and methamphetamines as recently of October of this year. She was also ordered to obtain suitable housing as of the date of this hearing. In fact, at any time in between, she's failed to show that she has safe housing. I was looking for references to her parenting time. Here we go. Last time she actually visited with her son was in November 15th, over a month and a half ago. Has been inconsistent with her parenting time, though, since August. Demonstrated a weakened bond with Dakota that was evident by observation at her visits. Given her lack of engagement, her prognosis for her being able to remedy the conditions that brought Dakota into care within a reasonable period of time are questionable at best. Even if she fully engaged today and remained engaged from now through the end of the case, which there's nothing based on her behavior to date that would suggest she could even do that, the amount of time that would be necessary in order for her to demonstrate to this court that she has indeed remedied the problems that brought her child into care is far in excess of what the court would consider reasonable given Dakota's age. Dakota just had his first birthday earlier this month. He deserves permanency. He deserves to have a mother who is able to care for him safely and who is engaged, who is capable of giving him the care that he needs and putting his needs over her own. She clearly has not established this. So the grounds that I identified earlier, MCL 19.3b, 3bi, reasonable likelihood that the child would be injured if returned, harmed if returned to her care. She's been responded in a proceeding in excess of 182 days. There's no reasonable likelihood those conditions would be rectified in a reasonable period of time given the child's age. And finally, rights to other children have either been terminated or released under threat of termination due to serious chronic neglect, similar to what we've seen in this case, similar allegations. So termination is justified on that basis as well for the mother. I'll wait to address best interests until I address the father's statutory basis. Based on the testimony that I heard, frankly, there's only one ground that I believe legitimately applies here, and that is Mr. Johnson has been a respondent in a proceeding. 182 days or more have elapsed since the issuance of an initial dispositional order. And the court finds by clear and convincing evidence that the conditions that led to adjudication continue to exist, and there's no reasonable likelihood those conditions will be rectified within a reasonable time considering the child's age. So as I look at Mr. Johnson's case, I agree with assessments that others have made in terms of his presentation today. Clearly, Mr. Johnson has realized some benefit from the services that he's engaged in. Both his therapist and he, by his own acknowledgement, has made believe that he has made progress in addressing his mental health concerns, learning how to deal with stress, learning how to deal with his anger, learning how to manage his emotions better, basically becoming a better person. and I think both on the testimony of Mr. Johnson and the testimony of Ms. Miller, that he indeed has bettered these situations. But the question to the court is, has he rectified them? And if he hasn't fully rectified them, can he do so within a reasonable period of time, given Dakota's age? Dakota's a little over a year old. He has been in care for the entirety of his life. What remains, although Mr. Johnson has indeed, by his own admission and by his therapist's testimony, improved his ability to manage his emotions. As recently as yesterday, he demonstrated that he hasn't arrived, that he lost his temper with Ms. Jennings and engaged in abusive language towards her. That gives the court reason to wonder, how is Mr. Johnson going to respond when his child doesn't behave in the manner that he expects the child to behave? The court has no confidence that he wouldn't immediately resort to the loss of temper when he's unable to address the behavior of an infant, of a toddler or near toddler, when they refuse to be comforted, when they simply refuse to be consoled, when you simply don't know what it is that's bothering them and you reach your frustration point. Now, what would normally happen at this stage is, before the court would ever consider reunification, there would be an opportunity to actually see how Mr. Johnson does interact with his child when his child presents behavioral issues. We can't do that. There's simply no feasible way for the court to do that when he was here, Mr. Johnson, even though visits were made available to him to visit in person, so there would be an opportunity to observe, has he indeed benefited from services? Has he learned how to control his emotions? Has he learned how to control his anger, regardless of who it is that's presenting the situation that angers him? I would not immediately assume that he would engage in the type of rage that he demonstrated in his communications with Ms. Jennings yesterday, but there's no comfort on the court's part that he wouldn't do the very same thing with his child. So, and the court's now at a point where it can't even have a mechanism in place within a reasonable period of time to figure out how that could happen. Mr. Johnson did not avail himself of face-to-face parenting time for the last several months, and then made the choice to move from Michigan, where the court would have the ability to explore how has he really benefited from services as it pertains to the care of his child. He's made that virtually impossible by moving to Georgia. Now, could that happen with involvement of interstate ICPC, with engagement of a bunch of professionals down in Georgia who are willing to continue to be involved while this court monitors the situation? That's probably possible given enough time, but we're already over a year in care. And the prospect of the court being able to indeed verify that Mr. Johnson has indeed sufficiently remedied the conditions that brought this child into care at a point where the court would feel safe reuniting him with his son, a son whose bond with him can only be minimal. where the only in-person visits, the only significant period of in-person visits were when the child was within 3 months of birth. And I would suspect the child probably doesn't even have a lot of memory of that. But even if he did, then, granted, COVID is not Mr. Johnson's fault. He would certainly not be criticized for something that he had no control over. But once those COVID restrictions were lifted, the opportunity for in-person parenting time was restored. Did he have hindrances to being able to go to those visits? I don't doubt that. But you overcome those things. Your child is the most important thing. If he is, as Mr. Johnson testified that he is, why doesn't Mr. Johnson's behavior match that? Why didn't he make the effort, whatever it took, to make sure he got to those visits to see his son? Why did he then decide in September to leave the state, to completely remove any opportunity for a visit in person and relegate this, at the time, less than a year-old child to nothing more than a video contact with his father? I want to commend Mr. Johnson. It's clear to me that he has indeed made significant progress in terms of addressing his mental health issues. He has done that. That's verified by his therapist, and it's verified by him. The fact that he's been able to sustain employment now for 3 months since he's been in Georgia, when he couldn't apparently hold down a job in Michigan, is indeed commendable. And I think it further demonstrates that he, from a personal mental health standpoint, has indeed benefited from those services. But we still have the issue of substance abuse. Granted, THC is legal in Michigan, but that doesn't mean it's right. That doesn't mean it's right for you when you're trying to address mental health concerns and trying to better yourself, to be relying on a crutch. And that's what I see the THC being, as a crutch, based on the testimony that I heard. I'm also concerned by positive testing for a prescription drug that he was not prescribed, Xanax, and acknowledging to Ms. Jennings that he's continuing to use Xanax, even though he doesn't have a prescription for it. When I say continuing, I meant at some point during the case. I didn't get a time frame that he acknowledged since he's been in Georgia that he's still using Xanax, but I don't really have any testimony there one way or the other. What I do have is testimony that during the case, he used Xanax. He admitted he used Xanax. In terms of the missed screens, that's not as troublesome to the court. The testing largely that he did submit to, I think that in terms of his risk for being on illegal drugs is not a concern for the court, but the concern with using Xanax when you don't have a prescription for it is indeed a concern. I believe the testimony today, despite the progress that Mr. Johnson has made personally, still convinced the court clearly and convincingly that although these issues have been addressed, they have not been fully resolved, and given his choice to absent himself from this state and the services readily available here, the court sees no reasonable likelihood that reunification could occur within a reasonable period of time, given Dakota's age. For that reason, although the conditions have been diminished that brought the child into care, as far as Mr. Johnson is concerned, they have not been fully rectified and won't be within a reasonable period of time, given the child's age. With respect to best interest, clearly, every child deserves permanency. The current placement has been fully addressing this child's needs. It's a placement where he is with his siblings, half siblings. I realize that's the same mother, but not the same father. And definitely this family has provided him with stability, and they are willing and able to provide him with permanency, stability, and finality. I do have to address the fact that there's placement with a relative. As far as Ms. Clemens is concerned, it's her relative. It is not Mr. Johnson's relative that Dakota is with. Sometimes when I see placement with a relative, particularly a relative who's willing to serve in a guardianship type capacity and keep a parent involved in the child's life, I will often lean towards something short of terminating parental rights, often a juvenile guardianship. But in this case, given Ms. Clemens' history, given the desire of placement to adopt, I find that the placement with that relative, as far as it concerns her, does not in any way militate against this court's decision that termination is indeed in Dakota's best interest as far as the mother's concerned. As far as Mr. Johnson is concerned, it's not even his relative. It's not someone that I would anticipate actively reaching out to their own relative and keeping them involved in the child's life. Instead, as far as he's concerned, it's a non-relative. For that reason, I don't believe that placement with Ms. Clemens' relative in any way works against this court's belief that termination is indeed in Dakota's best interest. So for all of those reasons, I am terminating both parents' parental rights today. And I want to say once more to Mr. Johnson, sir, I do believe you've bettered yourself. I realize this is not going to be an easy decision for you to accept. I get that. But I hope you don't let it derail your progress. I hope you stay the course. Stick with the course that you're on. Seek out the continued help that you've started to begin to benefit from. I don't want you to take away from this that I think you're a bad person. What I'm left with, frankly, is just the simple reality of where these facts put us today. I'm going to schedule this matter for a post-term. Well, wait a minute. Before I do that, would you pull up an advice and rights form? I normally have that in front of me, and I'm sure Shannon would have had it. I need to advise you, Mr. Johnson, of certain rights that you have upon termination of your parental rights to Dakota. Give me just a moment. There's a form that I want to go through with you on the record. Let me see if it's in one of my scripts. Okay, Mr. Johnson, you do have the right to appeal the order terminating your parental rights to the Court of Appeals of the state of Michigan. And you also have the right to file a motion for rehearing with this court within 14 days after the date of the order terminating your parental rights. That'll be today's date. If you do file a motion for rehearing and that rehearing is filed timely but denied, you have an additional 14 days after that denial to appeal to the Court of Appeals of the state of Michigan. An attorney for appeal and rehearing purposes will be appointed for you if you cannot afford one. You must make the request for that court-appointed attorney within 14 days of today's date. If the court appoints an attorney to perfect your appeal, which I certainly will do if you request it, we will furnish that attorney with the necessary transcripts and court records in order to prosecute your appeal. In addition to your appeal and rehearing rights, you also have the right to file with the Central Adoption Registry of the Michigan Department of Health and Human Services at any time a form that's called Parents' Consent/Denial to Release Information to Adult Adoptee. With this form, you can consent to or deny the release of the following information about you to your child when he reaches the age of 18. That information is your name at the time of termination of your parental rights and your most recent name and address on file with the Central Adoption Registry. If you do not file a form, Dakota, when he reaches the age of 18, can go to the Central Adoption Registry and request that information. If you don't want him to get that information, you have to file a denial. You can change your mind about that consent anytime you want to by just filing an updated form. And you can also use the form to keep your name and address current with the Central Adoption Registry so that if you want Dakota to be able to locate you, he will be able to do so. We will be sending you a copy of this advice of rights form as well as a form allowing you to request a court-appointed attorney. Mr. Johnson, did you have any questions for me?
Yes, sir, I do. I've done everything you guys have asked me to. I've done way more than I went out of my way. I've just done so much.
Mr. Johnson, let me stop you. I'm not going to answer questions about why I made my decision today.
My parental rights to my son. I've done everything.
Hold on, sir. I will only answer questions about the process going forward. I'm not going to debate with you the wisdom of my decision, the reasons for my decision. I've already made my decision.
So how is it fair for Dana to still get to see her kids with her mom and still see her son that she just terminated her rights on, but I'm the one out here doing everything the right way and you guys terminated my parental rights?
I gave my reasons, sir. I'm not gonna Justin, do you have any questions about the process?
Yeah, I do. Why is this? Can you send me my appeal now? Thank you.
I will do that. So we will set this matter for a post-termination hearing. Shannon didn't give me an order for this today, so we usually set them in about 3 weeks. Let's make.
So that would be January 19th. You doing it at a certain time?
Sir, honestly, the only reason because you guys
usually at 10 o'clock. All right, Mr. Johnson, I'm going to put you out of the hearing now. I've muted you a couple times. I'm not going to tolerate any more interruptions.
I've done everything.
Been going over for about 40 minutes.
January 19th.
January 19th at 10 a.m. Thank you, counsel. Whoever's involved at 1 o'clock, we'll see you shortly. I'm going to take a little bit of break. Thank
Thank
you
you.
all.